Last case to come before us today is state, I have the wrong one, hold on for a second. Is Shahinian? Shahinian?
Yes, ma'am.
Okay, close enough, all right, versus Shahinian. And you're here by yourself, so you have 15 minutes, Mr. Heath.
Thank you. Please, the court, as the judges are aware, this begins with Thomas Shahinian filing a petition for a civil protection order in the Summit County Domestic Relations Court against his father, Richard Shahinian. And I have not actually seen the initial filing with the statement on it, because that's part of that court's record. I don't know that it's relevant to this, but the court sets it for a hearing. Mr. Richard Shahinian has served approximately 15 minutes before that hearing with that paperwork. The court has a transcript of that hearing that is available to it. The important part of it, I think, is that the magistrate, Janice Guy, who hears the matter, very carefully asks Richard Shahinian on several occasions if he has been threatened. Asked if he's been threatened in any way, if he's been threatened over the phone. He says, well, there are things that he received in text messages that were disturbing. But other than that, he says, well, his father tends to yell and he's afraid of people who yell. But in terms of a general threat or some physical act of aggression that would frighten someone, he doesn't repeat that whatsoever. So the issue becomes, based on the testimony, does the court, based on the manifest weight of the evidence, have the right to issue that civil protection order that it then issues and is signed by Judge Quinn after that? And I would argue to the court that, one, there is a complete lack of any significant act. We can all say we're afraid of this, we're afraid of that. Right now I'm dealing with a 12-year-old at home who's afraid to turn the homework in because she's afraid the teacher will be displeased with the homework. I'm not sure how to solve that. But there's no clear act. The other thing that's striking is, and I say to the judges just to set up the frame of reference, 35 years ago when I started the criminal justice system, the husband came home Friday night drunk, and the wife was somewhat disturbed because that was the rent money, and she said something, and ended up with a bloody nose. The sheriff's department came and asked if he could, politely asked if he could find someplace to sleep it off and come back tomorrow. That was 35 years ago. Today, if the neighbors call to say, gee, the couple next door are screaming at each other, and it's upsetting, the police show up, and based on the way the law is written, they're going to arrest somebody. The pendulum has moved dramatically in another direction. Here, the dispute within a family of a son who seems to be working and separating from the parents, moving out, based on the record, you'll see that he takes Dad's car, Dad's cell phone. It would appear from the record he's still on Dad's health insurance, and then refuses to communicate with Dad. Somehow is treated as something more than that. The domestic relations court treats it as if the government needs to somehow control Richard Shahinian's behavior at that point with a civil protection order. However, there are a variety of mechanisms within our society, and all three of you have been judges either in municipal court or in common pleas court. There are a variety of mechanisms where a person can send a text that says, never contact me again. And if there's a text or a phone call, that becomes telecommunications harassment. They can have a police officer call and say, never come to my residence again. If they go there, that becomes criminal trespass. In this case, I would ask the court to examine very carefully, where in the evidence does it suggest that the nature of this is such that the person who is asking for that order needs it? The purpose of that order is to protect people who are vulnerable. The purpose of an order that gives somebody the right to the residence, purpose of a domestic relations order that says that the person who has been excluded and needs to continue to pay the utilities, is to protect somebody who has the right to that in a variety of ways. They're seen as vulnerable in some way, or they're seen as having signed up or committed themselves to a relationship that essentially establishes some vulnerability. This is an adult child. This is a person who voluntarily moves out, goes on their own. And the communication, while some of it's a little bit disturbing, is simply about doing some reality testing about the end of that relationship. Why would the court grant a civil protection order that would interfere with that? Yes, people have bumps in the world. My wife and I, both being lawyers, never raise our voices with each other, but the kids know when we're not happy, if you understand what I'm saying. However, people deal with these things in a variety of ways. I would say to the court that the evidence for purposes of that order simply is not on the record. It simply doesn't exist. Is there an evidence of some amount of conflict or some amount of tension? Certainly. But the threats and the vulnerability that a person would have to establish for the court is not there. With regard to the distribution of property.
Before you go on to the distribution of property, which is an important issue, what are we going to find in the record? What will we learn about this young man? I mean, is there anything that came out in the hearing about any special needs, about his childhood, about his emotional stability, that perhaps the magistrate did not share in her order? We're going to see anything?
To summarize the record, he says that he becomes somewhat disorganized when somebody's yelling, and he tends to, I can't remember the phrase he uses, but he tends to flatten out. He doesn't react well when somebody's yelling, he doesn't like that. And that as he was announcing he was moving out, his father was yelling. I don't think that that's set in a situation where it says he's more vulnerable to, a lot of us don't particularly like those confrontations, I guess is the best way to put it. It does not suggest a particular vulnerability. Says that there was one incident where his father slammed on the brakes and his brother was in the back seat or something, got bounced off the front seat backs that frightened him as a child. But that was many years ago and there had been no other incident but that. This was his response to the magistrate's very, very careful questioning about, gee, have you been threatened? You know, there's nothing about having been hit, nothing about having been threatened to be hurt and those things. Just some amount of upset or yelling and this one incident with a car that sounds like it was probably 20 years earlier than this event when they were children. Other than that, I didn't see anything there that would suggest that this was a special needs person or somebody who wasn't very capable of constantly living with dad's car, dad's cell phone plan, dad's insurance, and what have you.
Were the text messages admitted into evidence?
Some part of it was read into evidence, yes.
And you said some of the text messages were disturbing.
Well, the one text message, I guess by disturbing, and I'm sorry, Your Honor, one text message is, and I'm summarizing this, I could take the time to read it out of the record, but I'm summarizing it, is that essentially the father texts and says, I don't know if this is my son or his captors. The last message that was sent didn't make any sense. I don't understand it. If you're the captor, I'm going to find you eventually. Save my son and kill you. That would be the thing I'm saying is disturbing. It wasn't directed at the son. It was directed at, I guess the message was, if this is a third party who is putting this text message out, I'm going to come find you.
Isn't that a little bizarre?
I said it's a little bit disturbing. That it is not.
That they would automatically think that the person's being kidnapped and the captor is texting them and.
Or worse, to think that there's a code in that to send a message to the son with a veiled threat of violence. I don't know which person you are.
Well, it says if you are this person. It doesn't say, I don't know. It says if you are the captor, then this is what I want to say to you, is what it says very directly.
Is there any evidence that this child had, it's not a child anymore, it's 24. Is there any evidence in the record that over this child's 24-year lifespan that he never left home before without notice and with no communication with the family before? Is this the first time he's ever disappeared?
There is no evidence of that one way or the other, but the father is, it's part of the transcript will be the father saying, he left, I couldn't find him, I had no idea where he was, he wouldn't respond, and I was very frightened by it.
Which is understandable, obviously.
Well, the fellow in Cleveland, I can't remember his name, who had kept the women hostage in the basement for how many years? I would pose the somewhat cynical question I posed, that when the prison system allowed him to commit suicide, how many mothers slept better that night? And that's what I guess I would say.
What about menacing by stalking?
Well, the point is I understand what you're saying. There is no evidence that father made it clear he was looking for this son to talk to him, but he never found him. There was never any contact. Menacing them by stalking would be being within a reasonable proximity of somebody so you were there, that you had appeared at their work, appeared at their home, appeared at places where they were likely to be in order to have a confrontation with them. And there is no evidence of that whatsoever in the record.
It's your position that you could not do that electronically?
Well, a person could immediately, by electronically, say, I want no contact with you. And at that point, as I say, then you have two things. You have the menacing by stalking, although I hadn't read the statute clearly enough to know what that element is, but generally it's to be in the place where they are found. And the other issue is there is never a request for no contact. There is never a message back saying, leave me alone, stay out of my life, I don't want any part of you. There is never that. It's, as we know, the worst thing you can do to a human being is to ignore them. The father's pleas are sent over and over again for contact and completely ignored.
Except that the car registration needed to be renewed.
Yeah, there was that too. Well, there was a message about the health insurance, that the son was on the father's health insurance.
A message from
The
the
father
father to
said
the son?
something about that.
Why don't you speak to, in the time we have remaining, to the issue of the car and... yes.
Well, once again, the statute is designed, it's, generally a civil protection order in the General Division of Common Pleas Court. There are less reasons that that court has the right to order, support, or division of property, those kinds of things, if it makes any sense. In this case, essentially, the court orders in the domestic relations order that the father provide a power of attorney so the son can, the car needed to be e-checked in order to be re-registered. That was one of the issues. I don't know if that's in the record, but that was one of the issues. The father provided power of attorney so the son can then do that and maintain the car. And I don't understand, Your Honors, I've thought very hard about where in the law that relationship between a parent and an adult child, unless the court has sort of asked if the child with special needs or had some special needs, maybe the parent would have a duty to support. There is no evidence in the record that the parent has any duty to support whatsoever. And therefore, where would the court have the right to essentially order that property to be held by the petitioner in that matter and for the respondent to maintain it? I don't believe that by maintain it, I mean to maintain the insurance on it. There are issues that go with that because it's titled with that person, so they would need to maintain insurance to make sure they didn't have some liability because they're allowing another to operate.
It's an interesting intersection between this situation and the situation that some would argue exists where, between couples, where one person has the dominant, ability to control the resources, and which in most cases would be the husband, but not all. And the court issues a CPO, and the husband says, okay, you want me out of here? The car's in my name, you can start walking. And so the court has some discretion to be able to equalize that. So that here we have, but the statute or the rule does not really speak directly to the relationship either between husband or wife or partners or father and child. So here we have a situation with a father and a son who's an adult.
If I may, in interpreting it, the legislature very clearly recognizes when people get married, form a family, join their assets, and agree to that, that when that relationship fails, those assets will be divided to leave both parties in as good a position as possible, essentially, because they've agreed to join those assets as adults. However, this is a very different situation because an adult child who is not disabled has no right to the assets of the parents under any circumstances, unless they die intestate.
Yeah, then we're out of time. Let me just ask you a question pertaining to that. I understand that argument obviously legally, but was there evidence presented as to whether the son had paid anything for it, how long he used the car, all those type of things? I think he used it for years, right?
Well, he had used it for a period of time, but there was no evidence as to whether or not he had contributed anything to the purchase or the maintenance of it whatsoever.
And was it gifted to him? I know it was still in the father's name.
The evidence that was adduced at the hearing would at most show he was allowed, that the son was allowed to use it. The father was very clear it was still his car.
Well, the court will take the matter under advisement, issue a written opinion, and also release it on the court's website. So thank you.
Thank you very much.
The court will be adjourned.